As we go through, Dom will deal with the first part of the webinar, and I will deal with the second part of the webinar. But keep the questions coming. We've already had a couple of really helpful questions, actually, that we will deal with as we go through. We will deal with your questions as and when they arise. I'm supposed to be puffing. Emma tells me every week that I have to puff the next week's webinar, which is Paul and Susanna speaking on limitation, as you see, and we'll remind you about that at the end. Dom, I think that's all I need to say before I hand over to you, isn't it?
I think so. Thanks, Sarah. So thanks all of you for joining us. It's really great to see so many of you here. As you know, this is about the 2018 Package Travel and Linked Travel Arrangements regulations. And prior to those regulations coming into force, claims were brought under the old package travel regulations, which are the 1992 regulations, many of which are still being heard by the courts and are coming up for trial or are in the process of litigation. The 2018 regulations apply to package holidays and linked travel arrangements booked on or after the 1st of July 2018, so not to anything before that, as anything before that is encompassed by the old regulations. Claims under the 2018 regulations are now starting to trickle through, no doubt are already landing on your desk as they are ours, and we should in due course start seeing the courts dealing with these actual claims in court under the regulations, but of course they will be encompassed, unfortunately, by fixed costs. So under these regulations, what is your cause of action? And that's set out at Regulation 15, subsection 2 of the regulations, and for ease of reference, we've popped that on the slide for you. So in essence, the organiser is liable to the traveller for the performance of the travel services included in the package travel contract, irrespective of whether those services are to be performed by the organiser or by other travel service providers. So what does that mean? In essence, it remains an improper performance of the contract or a breach of contract claim. The cause of action, therefore, arises under English law, and the limitation period is that applicable under the English law, which, as you know, is 3 years from the date of the accident or injury. The position in terms of limitation is not quite the same, as many of you will know, if you have a claim where there is an injury on a ship or on an aircraft. If you have such a claim, then you have to bear in mind that the Athens Convention or the Montreal Convention may apply, and both have shorter limitation periods and slightly different consequences. In terms of the Montreal Convention, your limitation period is 2 years from the date of arrival at the destination, or from the date on which the aircraft ought to have arrived, or from the date on which carriage stopped. The right to damages, and therefore your cause of action, is actually extinguished following the expiry of that period, so you don't have the benefit of any real limitation arguments if you're late in issuing. So it's a substantive limitation in effect rather than a procedural limitation period, because the cause of action is extinguished. As to Athens, it's again a 2-year limitation period, but that's from the date of disembarkation, and it's known as a procedural limitation period in that it is remedy barring. So going back to Regulation 15, subsection 2 and our cause of action, you'll note that on the previous slides that there are a number of terms within that cause of action. It's necessary that we define those terms. And thankfully, the regulations do that for us, and they specifically set out those definitions under Regulation 2. So firstly, dealing with the term traveller, as you can see on your slide, that means any individual who is seeking to conclude a contract or is entitled to travel on the basis of a contract concluded within the scope of the regulations. And again, in terms of organiser, the term, that is also again under Regulation 2, and it means either a trader who combines and sells or offers for sale packages either directly or through another trader or together with another trader, or the trader who transmits the traveller's data to another trader in linked online booking processes. You'll notice there's also a lot of talk about travel services. That, for ease of reference again, is under Regulation 2 of the regulations, and it briefly means the carriage of passengers, the provision of accommodation, which is not intrinsically part of the carriage of passengers and is not for residential purposes, or the rental of cars or other motor vehicles and motorcycles, as well as any other tourist service that's not intrinsically part of a travel service within the meaning of that paragraph. So it's a bit of a mouthful. But it's important to bear in mind that the European Package Travel Directive 2015 has a number of recitals to it that are helpful in explaining the 2018 regulations. And recital 17 specifically says that transfers between a hotel and an airport should not be considered travel services in their own right. So that is something to bear in mind. Once you've established your cause of action, you then need to consider the evidence that you will likely require or indeed face at court. In terms of evidence from the claimant, you can of course expect them to give evidence, as well as obtain evidence from other guests or holiday companions. If you have a claim under the regs concerning a trip or slip in a hotel, which is something we see quite often, or an accident that isn't a food poisoning claim, the accident circumstances really are of particular importance, because often in these cases what we see is that there is a discrepancy as to how that accident is reported, either to the hotel or the tour operator, for example, or indeed in the pleadings and the medical report. And the same is true of food poisoning cases. If you have a food poisoning case, you often find that symptomology and the onset of symptoms can vary throughout the pleadings and the medical evidence, and sometimes in the medical records themselves when they have been disclosed. Now, I act on both sides of the coin, so I deal with both claimant and defendant work. And if I'm acting for a defendant, it's a line of attack I will look out for to see whether the circumstances of the accident have changed over time, whether there's consistency in the reporting of that accident. For example, I've had a case where someone said that they'd slipped down some steps in an entertainment area of a hotel, but in fact in the accident report at the hotel itself, it said that they had slipped by the swimming pool when they were running around. So it was quite different, and that's something to bear in mind. And if you're for a claimant, it's essential that you explore that with your clients and you explore with them why the onset of illness, for example, has changed by a significant number of days, or why the circumstances of the accident have been reported entirely differently, because it's a real problem. And the difficulty when you have a food poisoning case, for example, under the regulations, where the onset of illness has changed, is that it can actually impact the medical evidence. So what you may see is that you have a medical expert who has specifically concluded that this must have been a bacterial illness, or one that was a parasitic infection and not a virus, because of the onset of illness and the date when the illness came on. But if your evidence actually suggests that the onset of illness was later, and there's real inconsistency in that throughout the pleadings and the evidence before the court, that can then mean that the court almost disregards that medical evidence, because what the medical expert had isn't actually correct. And we know that these medical reports are often obtained pre-action, and therefore it's no doubt going to be raised in Part 35 questions, but you want to make sure that you eliminate that happening to ensure that you have the strongest case. In terms of other holiday companions or guests in the hotel, they can of course attest to how injured someone was, to accident circumstances if they witnessed it. They can also deal with quantum issues, so how much care someone may have needed, or how ill they were and what they were able to do or not do during the holiday. And often their evidence is quite helpful rather than unhelpful. If you're acting for a claimant, you may want to check in advance, of course, if the companion's evidence is going to undermine your case. And I say that because I've had a case before which concerned a gentleman who slipped when he was in the shower and grabbed onto the shower cord, and by doing so he suffered a laceration to his hand. And interestingly, the case was run that the shower cord was defective, when we got to court and his partner gave evidence, she gave completely different evidence to him and effectively said there was nothing wrong with the cord, that he was overweight and it must have been how he pulled it. So that is something you want to try and eliminate, because when you have that howler in court, there's not much you can do to get away from that. So that's something you need to check when dealing with the case. In terms of the defendant's witnesses and the evidence that the defendant will likely provide to court, it's not uncommon, of course, for a hotel manager or a food and beverage manager, if your case concerns food poisoning, to give evidence in these cases. And you may find that they do so either by video link, or they may provide a witness statement and a hearsay notice may be served. They can often, and they will do, attach different documents to their witness statements and exhibit them, such as the health and safety audits that have been provided by the hotel or indeed carried out by the tour operator, health and safety certificates, or certificates of excellence from TripAdvisor, which I see quite often. And I never quite understand why they provide a TripAdvisor certificate of excellence, because I've never seen a judge place any weight on it whatsoever. But there we are. You may find that the person giving evidence from the hotel from the basis of their witness evidence wasn't actually employed at the time of the relevant accident, and that's something to bear in mind for both claimants and defendants in these cases, because if they weren't employed at the time when the accident happened or the food poisoning happened, for example, how can they possibly attest to what the hygiene processes were in the hotel, or what systems were operating and how they were operating? They may have this whole host of documentation, but that doesn't actually really inform the court much, because they can't say whether it was being implemented or not, and their evidence then therefore carries quite little weight. But it's something that you need to bear in mind. And you may also find that, for example, a hotel manager gives evidence in a case which concerns food poisoning, and they'll say in their evidence, when you cross-examine them, I don't actually go in the kitchens, I don't know what they do, that's for the food and beverage manager. So sometimes it's a case of checking who you're calling to give evidence and who is actually being called to give evidence if you're on the other side, because you want to see, are they actually the right person to attest to the documentation that's been provided, because it can either really assist you or destroy a case. As to hearsay evidence, we've touched on this slightly already, but I often see in cases for claimants that TripAdvisor reviews are used to support your case. If you're acting for a claimant, of course, you see those if you're acting for a defendant. But I don't think that they're personally that helpful. And that's because the individuals who made the comments on TripAdvisor aren't there to be cross-examined. If they've said something in their post about food poisoning, for example, they usually lack the necessary specificity to actually assist. So if your client, for example, says that they are certain that they ate in this particular restaurant at the hotel and the chicken was pink, and they're certain that their illness was caused by undercooked chicken, you don't usually get that level of detail on a TripAdvisor review. And the symptoms, even if someone said that they did have undercooked chicken, their symptoms may be entirely different. So it's something that doesn't actually carry much weight, I find. But I also think it's important to bear in mind that they're entirely subjective. It's very easy for all of us to look on TripAdvisor and to find as many good reviews or bad reviews as we like, but actually you're only supplying essentially a hand-picked selection of what you want to show to the court rather than what's actually there. And so judges don't actually place much, if any, weight on those at all. Customer service questionnaires and parameter reports are the next thing that you usually see in these cases. And they're often used, as we know, to demonstrate that there haven't been any other cases of illness, for example, or there haven't been other cases of people slipping at the same area as the claimant. And they're usually used just to suggest that everything was hunky-dory and there wasn't a problem at all. Some judges do look at these more favourably than others. And in particular with parameter reports, they're very helpful, I find, to defendants when they're defending food poisoning cases, to suggest that there were no other similar illnesses reported at the relevant time. And so they could say, well, it's therefore more likely that they suffered a viral infection. And the reason they will do that is because they try and emphasise the point that's made in Wood and Toohey by Sir Brian Leveson, that it's always very difficult to prove that illness is a consequence of food or drink which was not of satisfactory quality, unless there's cogent evidence of others who have been similarly afflicted. Now, I've been on both sides of the fence dealing with these sorts of claims, and as I mentioned, some judges really do place a lot of emphasis on the parameter reports to establish that. But you have to bear in mind that the parameter report is essentially dealing with what's been reported to the tour operator. So it's not dealing with what's been reported to the hotel. And what you would usually expect to see is some sort of log or reception book or something like that from the hotel to show that actually there have been other instances of illness and accidents, for example, that have been reported. So it's not entirely encompassing everything that you may expect to see. In terms of the customer service questionnaires, you have some similar issues to TripAdvisor in that the makers of the complaint aren't there, but they can sometimes be far more detailed than TripAdvisor because they're answering more specific questions. So they can be quite helpful in that respect. But it's important to bear in mind, and going back to the point I made earlier about accident circumstances, that if you have someone who has brought a claim and says that they had a particular accident or they had food poisoning, for example, and they have provided TripAdvisor reviews or customer service questionnaires in respect of that and the injuries that they've suffered, they can then therefore be cross-examined on that. And again, there's often inconsistencies, and this is usually due to passage of time and memory, but it again becomes particularly important to check what they're saying the circumstances were or the onset of illness was, for example, because that's usually far closer in time to when they go and see their medical expert or when they go and prepare their medical report, which can then have more sway with the judge as to what the correct date of onset of illness was or how the accident actually happened. So it's something to bear in mind. Often claimants don't necessarily tell you that they've made these posts, and I have seen them provided by the other side to say, well, we found you made this post, and actually it says nothing of the sort of what you say. So that's something that you need to consider. And what's not on there, of course, which is another huge issue in these cases, is social media evidence. Courts are now quite routinely asking claimants to disclose pictures of their holiday or posts that they've made on social media regarding their holiday. And what you tend to see is, again, some difficulties in respect of that, because someone may have said that they were sick and staying in bed and they were confined to their room. You see them with a glass of Chardonnay in every single photo, which I've had before. And the claimant said that she was posing for the camera and that was the reason why, which did not go down well in the slightest. So it's something to think about. And if you're for a defendant, what I find that defendants are doing now is, prior to accounts being locked down, because most people when they start to bring these claims will be told to lock down their social media accounts, is they will go and have a look before, when the claim starts to appear in its infancy, and take screenshots of relevant evidence on Instagram, for example, that don't quite show what your client then later suggests. So that's something to be aware of when you're considering these sorts of cases. But I guess that means now it's time to hand over to you, Sarah.
Yeah, thank you. Dom's done all the brainy bit, so she's given you the cause of action and the pitfalls, potential pitfalls of the lay evidence, and I'm going to be dealing with the expert evidence. So just recapping and going back to the cause of action, the section Regulation 15 cause of action, of course, makes it clear that the tour operator is sort of vicariously liable for acts and omissions on the part of the supplier. So where a hotel has, for example, not got a good cleaning regime, or it's installed the wrong kind of glass so that it's not shatterproof glass, for example, in a big pane glass window, the hotel's at fault there, and the defendant tour operator is going to be vicariously liable for that. But how do you prove fault? And that's been the subject of quite a lot of case law, going back pretty much the whole time that I've been doing this job, which is about 1 billion years, and for quite some time before that. And it's now pretty trite law that you need to prove fault on the part of the supplier by reference to local standards. with a couple of caveats, actually. And it may be that the courts are recently moving away from that position. But the orthodox position is that in order to show fault on the part of the supplier, you have to show fault by reference to local standards. And the case that set that in stone really is Wilson and Best Travel, that you see referenced on the slide in front of you. So Wilson and Best Travel was a case where I think it was a child fell through a pane glass window. It wasn't made of shatterproof glass. It would have been made of shatterproof glass, or it should have been, had it been located in the UK, but it wasn't. It was located in Greece. And the evidence was that in Greece, it was acceptable for the window to feature glass of that thickness. And therefore, there was no breach of local building regulations. There was no breach of local standards. And as a result, the claim failed because the claimant had shown that the window would not have been acceptable by UK standards, but it was acceptable by the standards applicable to that hotel in that location. So Wilson and Best Travel is the authority in support of the proposition that claimants must show a breach of local standards. But there are caveats to that, even in Wilson, and those caveats are being crowbarred open more and more recently. So the second limb is that you have to prove a breach of local safety standards unless a reasonable holidaymaker would refuse to take a holiday at that location as a result of the poor standards ongoing at that location at the time. So for example, I've had a claim where there was a campsite, there was an uncovered well, and someone fell down the well. And we didn't need to prove a breach of local standards because the judge found that that was such a trap or hazard on the premises that actually a reasonable holidaymaker, when faced with that kind of hazardous location, would say, well, I'm just not going to that campsite because if I could fall into a well at any moment, clearly that's not an acceptable standard. So if there is a trap or hazard on the premises, you might be able to avoid getting evidence of local standards. The other way of avoiding evidence of local standards is that there are uniform international standards. And again, that comes from what was said by Mr. Justice Phillips, who, as he then was, in Wilson. So he's talking about things like hygiene standards, uniform hygiene standards. So if you have a food poisoning claim, I'm setting to one side that it's strict liability in any event as a result of the operation of the Supply of Goods and Services Act. But setting that to one side, there are international hygiene standards which all hotels ought to be operating. And if the hygiene standards are in breach of those international standards, there's no need to prove a breach of local standards because the hotel is in breach of well-known international standards. You need to be careful about that though, because a number of people have come a cropper on this. And in a case called Evans, the claimant tried to rely on Federation of Tour Operators standards, so the standards that the tour operators themselves try and impose on hotels. That didn't work, and the Court of Appeal said it didn't work because the Federation of Tour Operators are trying to raise standards all over the world. So just because they're trying to gold plate standards in various locations, that doesn't mean that the hotels ought to be held to those standards just because they're trying to do better. They're trying to raise those standards up. And for public policy reasons, apart from anything else, the hotels should not be held to a higher standard when they're actually trying to make things better with the suppliers. So FTO standards are not uniform international standards within the meaning of Wilson and Best Travel. Federation of Ski standards can be uniform international standards, can be considered to be those standards, but need not always be. There's a case called Goldborn, I think it was, in which an attempt was made to make those uniform international standards. Something that's been quite vigorously debated over the years is the case of reckless and dangerous driving. So where you have, for example, a coach driver on a transfer coach who is driving very recklessly, do you need to prove a breach of local driving standards in order to show that there's been a breach of relevant standards? And there's a case called, now listen, I wrote it down, Refford Smith and Air Tours, in which it was held that that was not necessary. So the claimant got home without any proof of breach of local standards in relation to driving. What you do need, though, is evidence of the highway code. So, for example, if you're going to say in the most obvious case is whether or not you drive on the left or the right, if you're going to say that the coach driver is driving on the wrong side of the road, as a claimant, you're going to need to prove which side of the road he ought to have been driving on by reference to the local highway code. So if you've got a case of reckless and dangerous driving, you probably need to show, just disclose actually, evidence of the local highway code, but you probably don't need to go further and get a report from a local driving standards expert. The same appears to be true of aircraft pilots. And we know that from a recent case, which I think was the Stewart's case, actually. So I'm sure that Chris will correct me if I'm wrong about that. It's completely unpronounceable for me, but it's Black and Green Trading is the defendant. And in that case, although it was slightly unusual, it was a strikeout case, so it wasn't a trial. But in that case, the judge gave a very strong indication that evidence of local standards on standards of piloting an aircraft was not necessary because there are uniform international standards about that. So everyone ought to be piloting aircraft in the same way and non-negligently. So it may well be that the reckless and dangerous driving exemption also applies to the driving of aircraft. If you do drive, no, flying of aircraft. So that also applies. And we've also had very recently a case called Begum and Maran, which is to do with shipbreaking. And it's to do with what happens when you sell a ship to a breaker's yard in Bangladesh. That's actually a Lee Day case, I think. Claire will correct me if I'm wrong about that. And the fact that the shipbreaking yards in Bangladesh all operate very dangerous standards does not excuse those practices, because the judge found, look, if these are dangerous practices, the mere fact that everybody is using them does not excuse you from using them. So this would be the second limb of Wilson and Best Travel. No reasonable holidaymaker or no reasonable employee would want to conduct their business within the parameters of those dangerous standards. But subject to those caveats, i.e., is it inherently dangerous? Is it something about which there are uniform standards? You're going to need to get local standards evidence. And in a recent case, which is a Travelall case actually, Lockheed and On the Beach, the Court of Appeal said that if you do not get expert evidence of local standards as a claimant, you do so at your peril, because it is for the claimant to prove evidence of local standards, not for the defendant. Parenthetically, I've always thought that was wrong, actually. I've been thinking that was wrong for about 15 or 20 years, but the Court of Appeal has repeatedly told me that it's for the claimant to prove and not for the defendant, notwithstanding the fact that it would actually be easier for the defendant to prove what the local standard is. But be that as it may, acting for a claimant, you must prove a breach of local safety standards in most cases. Acting for a defendant, if the claimant doesn't have that evidence, you just stay quiet. And I've seen a number of cases where defendants have very keenly gone off and got evidence of local safety standards, which actually plugs that evidential gap. But no, if you act for a defendant, you just stay quiet about it. You plead it in your defence that there's no evidence of breach of local safety standards, and then you just sit back and wait for the claimant to either get that evidence, in which case you challenge it, or not get that evidence, in which case you turn up at trial, you say, well, they just haven't satisfied the burden of proof that they ought to have satisfied. So it's going to be necessary in most cases to get expert evidence of local safety standards. So what expert do you get? We see a lot of lawyers, a lot of engineers giving evidence about things like, as I say, let's take as an example, the thickness of glass in windows. And you can either get evidence from a lawyer or from an engineer on that. Because if you were to ask Dom or me what building regulations there are or what you need to do under the Occupiers Liability Act, we'd be able to tell you the answer to that. So a lawyer can tell you the answer to how thick glass needs to be or to frequency of cleaning and things like that. And that's perfectly acceptable, it seems to me. People also get evidence from engineers because they're more specialised. So for example, where you've got building regulations involved, things like water park specialists, what does gradient need to be on a water slide? How much water needs to go down the water slide? You're going to need to get a specialist on that. And we get lots and lots of accidents happening in swimming pools. So you'll need to get an expert on water safety in that particular jurisdiction. And it's really hard work, actually, because some jurisdictions are really difficult to find experts. For example, Cuba, because anyone living in Cuba or having a specialism in Cuban law, anyone coming from Cuba, doesn't want to criticize Cuban hotels, because all Cuban hotels are partially owned by the Cuban government, which doesn't take very kindly to people criticizing their standards. So Cuba's a very difficult location. We do have a couple of specialists who now don't live in Cuba who feel able to give us evidence of local standards which says that the hotels are not complying with them. I've seen evidence given by two experts at once. So I've seen a lawyer and engineer producing a sort of hybrid report. So you're hot tubbing your own experts, as it were. So you've got a lawyer and an engineer both contributing to a report. I see the sense in that, because it means that you're covering all possible bases. So your lawyer tells you what how thick the glass ought to have been, and your engineer says, well, looking at the shards in the photograph, I can see that it wasn't actually that thick, and then they produce a hybrid. For what it's worth, I've had difficulty with that, and it actually becomes quite difficult when they come to give evidence, because do you cross-examine them both at once if you're out for a defendant, or do you hot tub them when they give their evidence? I've seen that done, and I've seen each expert blame the other for anything that was wrong in the report. So under cross-examination by the defendant's counsel, the engineer would say, oh no, that was the lawyer's bit of the report, I didn't write that bit. And the lawyer says, no, the engineer wanted to say that in the report, I didn't write that bit. So I actually am not a big fan of those hybrid reports. It's something we've tried. I don't think they work terribly well, actually, because nobody owns the report. Nobody takes responsibility for the report. And another thing that I've seen done is that there's a particular English engineer who gives evidence about local standards all over the world in relation to absolutely everything from water paths to water slides to speed cameras to cleaning regimes. And he often asks local specialists or asks local experts in whatever relevant regime it is to help him out, giving him some help with what the local standard actually is. That's also very dangerous, because it means that when you come to cross-examine that expert, you say to him, well, actually, this is not your evidence. This is evidence that you've got from somebody else. So you really need to select the right expert who actually has an expertise in this particular area, and thinking about the area quite carefully, rather than just saying, oh, well, I always use this English engineer, so I'll just use him again. The other area that needs to be quite specific is where you've got a case with a disabled, for example, claimant, who alleges that the provision of the services was not disabled friendly. So, for example, you get someone who's in a wheelchair and the tour operator has sent them to a hotel which has lots and lots of steps. Or, for example, the wet room isn't appropriate or doesn't have appropriate equipment. You will then need to get a specialist in that particular field, i.e. in the provision of equipment, aids and equipment in that particular country. Because in particular with disability, you find that there are wildly different local custom and practices. And some of them we would regard as being Jurassic, I mean, just ancient. So you need to get the right specialist in the right field and get the right report from them. So instructing the experts, once you've selected the appropriate expert for your needs, you then need to ask them the right question. And I know this sounds terribly patronizing, but we do see all the time the experts being asked the wrong question. So what do you want from your expert's report? Well, you want to know what the local standard is, and that's both regulatory, i.e. written down somewhere, statutory or other regulatory, but also custom and practice. What you're not asking the expert for is a report on local law, because don't forget, Dom's just told you that we're considering these cases under English law, but applying local standards. So you don't want to know what the Spanish law says about this. You don't want to know that in Tunisia the burden of proof reverses. You don't want to know that there's strict liability in France. What you want to know is, what do we expect in France? What do we French people expect in France of our hoteliers? What do we expect in Spain of our excursion providers? Not what is the law, is there strict liability? And you see it all the time. And Dom was telling me the other day about an expert who just filled their report with Halsbury's statutes, which seemed a bit wrong-headed. And whether they'd done that in response to the wrong instruction or whether they'd gone off and done it on a frolic of their own doesn't really matter. What you need to end up with is a report that tells you what the local standard, not the local law is. Don't ask the expert either what the local courts would do. So what you're not saying to an English judge is, well, the Spanish courts would find in favour of the claimant, therefore you must find in favour of the claimant. Not only do English courts not like being told you must do X because the foreign court would do X, it's also not the right question because those courts would be applying local law. And the caveat to that is that it can be helpful to know what the local case law is. So the contents of the report, having asked the right question, what do you want the report to do? Well, of course, it's got to be CPR compliant. And again, I know that sounds terribly patronising, but you would be surprised how many we see that aren't. It must answer the question that you have asked on local standards. So if a report comes back and it doesn't answer your question, you just send it back to the expert and say, look, you've just not answered the question. It must not relate to local law. So it shouldn't contain anything telling us the relevant provisions of the Spanish Civil Code. It shouldn't tell us anything about the American legislation on this. But it can tell us that there's been case law locally on a similar accident in which the judge held that the supplier was to blame because they were at fault. So the case law can be instructive, but only if it relates to very similar sets of circumstances. What you don't want is case law that tells you tort law in Spain because it's completely irrelevant, bearing in mind that you're governed by English law. Once you've got the report, do you ask Part 35 questions? The golden rule of litigation always is only do anything if it's necessary to do it. Never do anything you don't have to do. And it's never more so than when you're asking Part 35 questions. I have seen so many cases come apart because a party has plugged gaps in evidence by asking Part 35 questions. Part 35 questions are not really there to get the expert to change their mind because experts never change their mind, they always double down. They are there where if you have something you think is a killer point, where you can say to the experts, hang on a minute, you've given us information about these building regulations, but actually they don't apply because the hotel was built 5 years before the building regulations came into force. Or hang on a minute, there are some new regulations that say something completely different, or hang on a minute, you've mistranslated those regulations. In those circumstances, Part 35 questions are really useful. But if you're just trying to persuade the expert they're wrong, Part 35 questions are not going to take you any further and are likely to plug a gap. And I actually had that only a couple of days ago where a party asked my engineer some Part 35 questions, which were essentially, aha, there's a big gap in your evidence, you haven't considered this. And the expert said, oh, right, okay, yeah, you're right. Now that I've considered it, it actually supports what I've said. So I'm doubling down on what I said in the first place. I've plugged the evidential gap and I'm twice as sure as I was before that I was right in the first place. And that's just completely unnecessary. What they ought to have done is wait for trial and then point out the gaps in the expert evidence. So having not asked Part 35 questions, what do you do to prepare for trial? So where are we going with our pre-trial checklists? Well, do you want the experts to give oral evidence? If there is a gap in their evidence, you as the defending or the other party don't want the experts to turn up and plug that gap. So just leave it. If there's a gap in the evidence, as far as the defendant is concerned, that's the claimant's problem. If there's a gap in the evidence, the claimant really needs to plug that gap, so you do want your expert to give oral evidence. Consider your expert. Have they ever given evidence before? Are they coming from a country where giving evidence is very intimidating? Are they coming from a country where giving evidence is not intimidating at all? I had a chap years ago, a Turkish expert, giving evidence by video link, and midway through, he got himself a cup of coffee and lit up a cigarette, leant back in his chair, and sort of took on a sort of position of utmost ease. That was not very helpful. You need to tell your experts how we give evidence in England because it can vary wildly from country to country. Consider video link, as I say, and more that's going to be done. And we do that already, of course, with most people who are getting evidence from abroad. They need the bundles, and they need whatever holy book it may be that they want to swear on. And again, it's surprising how frequently you have experts who don't have the bundle. All they have is their report and a sort of sheaf of papers that they shuffle throughout giving their evidence. So they need the bundles to be sent to them. And for that reason, you need to be thinking about preparing the bundle much earlier on in these cases than you usually would, because the expert needs to see everything. Bear in mind, of course, that your expert may not have seen everything at the time you first instructed them. So if further disclosure becomes available, if further witness statements become available, you will need to provide those to your expert, because it might change their minds. And once they've seen something in the bundle, once they've seen, for example, the pleadings, it may be that something, it triggers something, and they think, well, actually, my evidence does need to be different in some way. So they need the bundles earlier rather than later. Consider realistic time estimates. Please ask us. It's not just in these cases, but please ask trial counsel. I did a pre-trial review not long ago where we had 8 witnesses, and the question I was being asked was, do we want the evidence to give, do we want the experts to give oral evidence? There are 3 experts. And I said, well, what's the time estimate? 1 day. Okay, we've got 8 lay witnesses, of whom 2 or 3 are going to be giving evidence by video link. If you want 3 experts each to give oral evidence, you're looking at a much, much longer trial. I'm going to have real difficulty getting it within 1 day in any event. So that trial estimate actually was not really realistic. So it's really helpful if you ask trial counsel, as I say, in all cases, what the time estimate ought to be. Bear in mind that with video link evidence, everything takes twice as long, because it never works first time. It takes ages to set up. There's always toing and froing. And if you've got an interpreter, that throws something else into the mix as well. So your time estimate's going to be quadrupled. Having considered all of those things, having asked us for our help on the pre-trial review, sit back, you've done all you can. You've got your lay evidence in, you've got your, let's say you've got, the claimant's got TripAdvisor reviews in, so the defendant's counted that with their TripAdvisor, this is the Hotel of the Year type reviews. The judge is going to discount both of those completely because they're both hearsay. But you've got your expert evidence of local standards, you just sit back, you let us deal with the rest of it. Talking of which, we've got some questions, I think, Dom. Oh, the first question that we were asked beforehand, and this is from Anne Saunderson of Foster's, so thank you for this. This is a question about Brexit. Is Brexit going to have any impact on these cases? The answer to that is actually no. It's the one area where Brexit isn't going to have any impact, because they're claims brought under English law, and they're claims brought under the regulations which we have incorporated into English law in 2018. So these cases, being governed by English law but foreign standards, are going to carry on in exactly the same way, and there's going to be no enforcement problems either, because you've got an English defendant in the tour operator. So actually in this area, Brexit does not affect us in any way. In a couple of weeks' time, we'll be doing a Back to Basics webinar on foreign traffic accidents, and Brexit will have a huge impact in that area. But in this particular area of our practice, Brexit's not going to be an issue, so we just carry on as usual. So, Dom, what have we got on questions?
So we have Darius, and he said, what or which standards would apply, do you think, to a swimming pool on a cruise ship registered in state X on the high seas and alongside in, say, a UK port?
Yeah, thank you, Darius. Darius has a long history of asking us difficult questions on these webinars. And in fact, once asked me a question so difficult that I had to go away and write an article about it of about 5,000 words. So, you know, thank you for that, Darius. I'm going to ban you from these. The answer to that question is, it's a really difficult question, because a cruise ship is governed by the Athens Convention, of course, as Don was saying. So the first headline is 2-year limitation period. But we have all taken, we as travel practitioners have all taken the view that because the Athens Convention is a freestanding convention and has its own applicable law, it's got its own jurisdiction, it's got its own limitation period, it's internally a complete cause of action. We've all taken the view that local standards don't really apply in those cases, because otherwise you would have to have the structure of the vessel. So let's say the decking would have to comply with English local standards if you're within English waters. It would have to comply with American standards if you're in American waters. Or does the fact that it's flagged in Panama mean that it has to be, the decking has to comply with Panamanian standards? And if it's then reflagged, does it then have to comply with some different standards? So the view that we've always taken is that local standards don't really work with the Athens Convention. So all you're looking at then is fault, because you have to prove fault under the Athens Convention unless it's structure of the ship. So we've kind of fudged it to date, and that's worked quite well for us. And considering how long the Athens Convention has been going, the fact that we've had no local standards issues is a testament to the fact that all travel practitioners don't know the answer to that question. No one's taking the point. There was a case called Dawson and Carnival, which involved someone slipping on orange juice. And there was a question about whether or not that slipping accident, whether or not she got home on that slipping accident. And there was no local standards issue on that. So no issue was taken on it, Darius. So I think the answer is you're overthinking it or we're underthinking it. And I actually suspect we're underthinking it. But the answer cannot be that the standards are different, whether you're in international waters or in national waters. So if I had to choose a local standard, it would probably be the flag nation. But that sits very uncomfortably with the rest of the consumer legislation. So the answer is we fudged it, and I suspect we're going to continue to fudge it. I know that's not helpful.
We've got one from Sandeep that says, what are your views on the merits of using an English expert on local standards versus a local lawyer or engineer?
I would always rather use a local expert, because if you use an English expert, it's really easy to cross-examine. You'll have done this, Dom. It's really easy to cross-examine that expert and say, well, you're English, what do you know about it? And particularly if it's an English expert who has no particular qualification in that nation. So if you've got an English expert, an English engineer, for example, who on their CV professes to have an expertise that goes globally, it's very easy to cross-examine that expert to say, well, how can you possibly have an expertise in all of these different things in all of these different countries? You're not properly qualified. So it's always preferable to get a local one if you can, but I do accept that in some nations it is very, very difficult indeed. But in the hierarchy of experts, I would always use a local one. I don't know about you, Dom.
Yeah, I would always use a local. I think there's some particular experts we see time and time again, Sarah, don't we, who are based in England, who profess to be able to deal with things abroad. And the problem is also, if you have a claim where someone slipped on a particular set of steps or something like that, sometimes you will need slip tests carried out and the like. And if they don't live there, it's really difficult for them to be able to do that. And so the expert report can be a bit lacking. So I tend to find that local standards experts, as in ones that are actually locally based rather than the UK, are much better. Yeah,
I agree with that.
So we have one from Luke, which says, if you're a qualified and experienced building surveyor, can you testify as a surveyor, as a surveyor specialist, or as a lawyer?
If you're dual qualified, you can testify as either and both. So if you are qualified, then you can testify, or actually if you're experienced as well. So in Lockheed and on the beach, there was the Court of Appeal said, yes, you've got to get this evidence of local standards, but it need not be someone who's got formal qualifications. It can be someone who's just really experienced in that field. So yeah, you can testify as either or both. If you're dual qualified, you can testify as both, and that's great. So I suppose that answers my hot tubbing issue, which is that you're getting two experts for the price of one. So yeah, I mean, that would work.
And then I have another about fixed costs and travel claims. And do they just apply to gastric illness or other travel claims?
They're gastric illness, I think. I don't do very much fixed cost work. So I think the answer to that is it's just illness. But I imagine somebody else, another attendee, will know the answer to that. But because I don't do very much fixed cost work, I think it's just illness. Someone will tell me if I'm wrong, I feel sure.
I think that's it.
It's just illness. Yeah. Thank you, Nick. I knew someone would be able to help me out. I shouldn't have been so tentative. I should have done what I usually do and just go, yeah, absolutely. It's completely that. I'm just looking at the chat. Chris actually points out and makes a really good point about this, Chris Deacon, that a site visit is absolutely invaluable. Yeah. And again, if your expert doesn't do a site visit, you're laying yourself open to cross-examination on the basis that you've not actually been it. You weren't there. So you haven't seen it. So it's not always proportionate. It depends on the case. But Chris is right. Sometimes a site visit is absolute gold dust. And if it's a sort of slightly meatier case, it really justifies a site visit. And they ought to be doing a site visit in any event.
Definitely.
Claire asks actually on the chat, is it preferable for your expert to do the report in their own language and then we translate it into English? It's a real lawyer's answer, isn't it? It depends, doesn't it?
I think it depends on their ability to give evidence in English, doesn't it, really? If they feel that they're able to give their evidence in English and they don't require it to be translated and they don't require an interpreter at trial, then you're probably fine then for it to be in English. And if there are any misunderstandings, you're sort of stuck with it. But if their ability to speak English is such that, or their level of understanding of English is such that they're not going to be able to participate without an interpreter, then I think then that may be that you put it in their own language. But otherwise, I think you'd run into a problem where a judge would say, well, if your expert can write this report in English and seems to have understood everything, doesn't need an interpreter, then it puts you in some difficulty, I think.
Yeah, I agree. And I think particularly with experts, they need to be quite precise about things. So there needs to be some precision in, for example, if there's a local regulatory regime, they need to be able to translate that with a degree of precision, because sometimes the precise words used really count. Things like depth of treads on stairs and stuff like that, they need to know what a tread is. That's quite important, or what dimension they're talking about when they're talking about depth, treads, widths, and so on. So you need to be absolutely, or the judge needs to be absolutely confident that your expert knows what they're talking about and means what they say. And that can only be done, I think, if they've either got a really good understanding of English or if you've translated. So I'd always, but then I always do err on the side of caution, but I'd always err on the side of getting it in their first language and then translating it, which I know is a pain. I'm sorry, Claire, but I think it's more prudent to do it that way.
And I have had a trial where I've had a local standards expert beamed in via video link, and they've got someone who's interpreting next to them, and it's absolutely fine. There's no issues with it. But I think you've just got to think about it carefully.